Good morning. I'd just like to begin with some housekeeping issues. You got a survey when you registered this morning. If you're able to complete that and either hand it to one of the student ambassadors, you'll see this morning there will also be boxes at the back of the auditorium. If you could do that prior to the lunch break, that would be a tremendous help. Thank you. First, by recognizing Justice O'Connor, other members of the Supreme Court, the staff and leaders here at Georgetown Law, also, of course, Meryl Chertoff, my distinguished panel, and the honor who are here. It is a real privilege to be part of this discussion. I'd like to begin with the question before us, which is, can corporations be brought back to the courts as a dispute resolution mechanism, and should they? One of my jobs as a journalist is to take complex issues and try and break them down to their simplest, some of the facts as I see them. The premise is that corporations, for a variety of reasons, this is not a unique situation. We see of private citizens as well, and what strikes me is that though the stakes can be quite different, they're using a lot of the same factors in their decision-making process. Perhaps first and foremost is the cost. And in my brief discussions with people, they will say the burden of discovery, a lengthy discovery, especially in this electronic age, can just be prohibitive. There's the issue also of time. Everybody wants their problem solved quickly. For many of us, it just gives you a chance. For corporations, it gives them a chance to plan. And that is a key piece for a corporation. If you are able to plan for your future, there is less risk, you can minimize your costs, and ultimately your responsibility is to the shareholder. In addition, we all want our problems solved by somebody who's very knowledgeable, who knows what they're talking about, who's up to date on the latest information. And one of the facts we heard from our earlier panel is corporations are increasingly reluctant to have very complex disputes resolved by juries. Our panelists are going to address several of these issues this morning, and I hope there will be time to address a point, at least that I am interested in. If we can bring corporations back to the courts, does this serve a greater public good? Does this help build trust in the courts? Does this help strengthen its standing within the community? This morning, I will introduce the panel, and I will do it in the order that they will be giving their opening statements. I'd like to keep my introductions brief so that we can maximize the time for the discussion, and then I would very much open up our discussion and our debate to those in the audience. To begin, Romero. She comes to us as a corporate counsel at DuPont, where she's responsible for legal oversight of the acquisition of transportation, distribution, supply chain management, energy resources totaling billions of dollars each year. During her career at DuPont, Ms. Romero was also in the litigation group and managed complex commercial and antitrust cases for the company. Ms. Romero is also president of the Hispanic National Bar Association. She brings a very valuable component to the discussion today because she can talk about the internal decision-making process that happens in every corporation when they face this question. Ramona, if you will, is right there in the trenches. I also wish to recognize the Honorable Fern Smith, who has served as a federal district court judge, combining 30 years of distinguished judicial and legal experience with her unique ability to bring about successful resolution of complex multi-party matters. Judge Smith also brings an international perspective, having served as a trainer and facilitator on judicial administration and reform with judges from the Middle East, Asia, and Africa. Judge Smith extensively about the legislative piece here. Are there federal procedures in place that are just making the courts less attractive to corporations? We'd also Justice Randy Holland. He is the youngest person to ever serve on the Delaware, having been recommended to the governor by a bipartisan merit selection committee. In 1999, he was reappointed and confirmed unanimously for a second 12-year term. was recently appointed as a member of the ABA Presidential Commission on Fair and Impartial Courts. And of course, we also have Kenneth Feinberg, who is known to many of us through his work for the September 11th Victim Compensation Fund. In the wake of this catastrophic loss, Mr. Feinberg was appointed by the Attorney General to serve as special master to the fund. He developed and implemented all aspects of the program. Mr. Feinberg is considered one of the country's leading experts in mediation and alternative dispute resolution. And today he can speak to, I think, an important issue, how ADR and mediation are meeting the needs of the marketplace. And perhaps they may be in a better position or more able to evolve with the needs of the marketplace than perhaps our courts. Romero.
Good morning. It is truly a privilege and an honor to be here. First, I must start with a disclaimer. I am not here to speak for DuPont specifically or for the Hispanic nation. Instead, as Catherine said, I'm here to offer the views from the trenches. Those views have been shaped by 19 years as a commercial litigator and 1 year as a transactional lawyer. I've been both at a large company and also at a large law firm. My views, the views I'm going to share, are also further informed by a number of discussions I had with colleagues at other Fortune 500 companies in preparation for today. I'll make an effort to answer both of the questions posed to this panel. First, can corporations be persuaded to return to the courts to resolve commercial disputes specifically? And second, should they? Inherent in the first question is the presumption that companies have left the courts in droves. I'm not sure that I agree with that presumption. In my experience, there's no uniform view among in-house lawyers concerning the desirability of resolving commercial disputes in the courts. The attitudes of individual counsel are shaped primarily by the functions they serve within their companies. Most of the in-house litigators I know, for example, are very favorably disposed towards mediation. Most of us, however, are afraid of binding arbitration. One of the primary positives often attributed to arbitration is finality. It's also perceived by litigators as its main liability. There's also the perception that arbitrators as a group have the propensity to try to imitate Solomon and end up, in fact, splitting the baby. Virtual awards is so very difficult, and as Justice Souter knows and has said, it cannot be. We cannot contract for an expansion of judicial review. In-house litigators actually prefer giving the chance for appellate review. But as we all know, decisions concerning how disputes are to be resolved are generally not made by litigators. They are made, at least with respect to business disputes, they are made much earlier in the process. They are made primarily by lawyers who are in the position that I'm in now, that is, the lawyers that advise businesses during the development of business-to-business contracts. The views concerning dispute resolution are, again, far from lawyers who support corporate sales transactions, IP licensing, and similar commercial endeavors tend to favor binding alternatives over the court. Those colleagues place great value on the ability to select experienced and sophisticated arbitrators, and on the enhanced confidentiality that is offered by private proceedings. They also favor the fact that well-designed arbitration provisions can preclude customer corporations from bringing class action lawsuits against their corporate suppliers. In the words of quote, companies that sue their suppliers should go mano a mano. He's not Hispanic either. Instead, they try to stack the deck by ganging up their class actions, enhancing the risk and cost of litigation to such a degree that defendants have little choice but to settle even the most meritless cases, end quote. As someone with substantial experience defending both DuPont and other companies in antitrust class actions, I can tell you that I am all too familiar with the dynamics of that scenario. On the other hand, in-house lawyers who support corporate buys, that is, people who are in positions like the one I'm in now, that are likely to ultimately come to disputes that where their companies will be placed, preferred ADR provisions that preserve the right to litigate. At DuPont, this difference in approach is form contracts used by the lawyers who support buys versus the lawyers who support sales. The seller's contract templates call for negotiations followed by but end in binding arbitration. The purchasing form contracts, on the other hand, call for negotiations followed by mediation but end in litigation. Only in rare cases do purchasing contracts provide for binding arbitration. Now, given my belief that there's no overriding preference for ADR lawyers, I suggest that the answer to the first question is a resounding yes. As Ken Frazier made clear, even in the context of tort litigation, companies are well disposed to using the court system when appropriate. To the extent that corporations have opted out of the courts, they can be brought back if steps are taken to address some of the major negatives perceived by the in-house legal community. The productivity and economic burdens associated with limited discovery tops the list of concern. In your DuPont executive, every dollar spent on litigation is one less dollar available for research, product development, and capital investment. And let me tell you, for a company that invests in usually on the average year about $120 million on litigation matters, that's a lot of dollars. Another important driver is the perceived inability of many cases. Delayed in significant commercial matters creates undesirable uncertainty in economic interactions. Finally, corporate counsel from the activist judges' rhetoric that afflicts the rest of society. Some are reluctant to entrust their cases, and here I quote again, to judges who are all too willing to make public policy at the expense of the intent of the parties, end quote. Unless the judicial system can develop credible responses to these and similar concerns, the use of binding ADR processes is likely to increase. The good news from my perspective is that some courts have, in fact, been able to respond to those issues very effectively, as have the Delaware business courts, and Justice Holland will speak a little bit more about that. As to the second question, whether companies should be back to the courts, there are multiple considerations that impact both the private and the public sectors. I offer three brief thoughts. First, as Ken Frazier noted, the courts are severely overburdened. To the extent the binding ADR processes relieve some of that burden, they are not necessarily a bad thing. There's no doubt that both corporations and society benefit from the certainty derived from precedent-setting judicial interpretations of the rules that govern commercial interactions. Thus, at the risk of stating the obvious, ADR processes cannot and should not supplant the judicial system. Finally, both society and potential litigants derive the greatest value from the early and expeditious resolution of disputes through negotiation. In addition to imposing the lowest burden on both the parties and the taxpayer, negotiated resolutions produce the least acrimony. That is, they help the parties preserve their relationship and go on to deal another day. Thank you.
Ramona, thank you. I'd like to bring in our second panelist, the Honorable Fern Smith.
Thank you. Thank you for that nice introduction, and good morning, everybody. Like the other panelists, I join in expressing my honor at being a part of this, thanking Justice O'Connor, our hosts, Justices Souter and Breyer, and welcoming all of you. My remarks and my thesis are pretty straightforward. They're unsupported by any empirical evidence, and they are focused basically on the federal courts, which is what I know the best. But it's simply this. If some corporations are leaving the federal courts, what is it that's causing that? And second, do we want them back? The thesis is basically this, that over the past 25 years, a combination of legislation, changes in rules, and court decisions, traditional litigation more complex, more expensive, and therefore less attractive to corporations. Even though many of the changes that have been made are typically viewed as defense-oriented, in other words, changes that were meant to put a curb on legislation. While that may be true in isolation, anything that causes litigation to be more complicated and raises more collateral issues affects both to a dispute, whether the theory is in your favor or not. If there's time for my 6 minutes, I have a secondary response to Ken Frazier. He's being quoted quite a bit. And that is whether or not the courts really could stand to have all of the courts back. From a practical matter, while I may be in the ADR world now, I still view the world primarily as a trial judge. And I shudder to think of what would happen to my court were not only Vioxx, but Bextra and Celebrex and Resolin all there in the same time, and then you throw in a couple of IP cases from Microsoft and Oracle and Apple, etc. I don't know that the courts could withstand the burden of that. So to me, having the alternatives of both is best of all worlds. But getting back to my original thesis, what's happened in the courts that have created this expansive complication? Let's go back to 1983 when Federal Rule of Civil Procedure instituted the Rule 11 mandatory sanctions. Between 1983 and 1993, there were over 7,000 reported decisions on Lexis on that rule alone. And while it's no longer mandatory sanctions, that collateral issue still rears its ugly head. In 1986, we had this summary judgment trilogy: Liberty Lobby, Celotex, Matsushita. Whether or not those whether or not more active case management oriented judges are responsible, as the Federal Judicial Center believes, summary judgment has become a huge and expensive factor in litigation. In 1991, we had Chambers versus NASCO, which legitimized inherent judicial power, giving courts and judges who believed in case management even more liberty and freedom in designing what they felt were appropriate case management techniques. 1993 brought us Daubert and the new mandatory disclosure rules. Daubert, of course, gives judges the gatekeeper responsible over expert testimony. And although it was intended to actually liberalize the evidence of forced expert opinion, what it really did, or I think what has been proven, is that it has led again to a collateral issue of Daubert here, which at times, in large cases, in and of itself run into the high six figures. In addition to that, you have the mandatory expert reports, and the exclusion of expert testimony is becoming fairly common. 1995 brought us the PSLR attempt to rein in security class actions. That was followed later by SLUSA in 1998 and CAFA in 2005. Now, those are good examples of rules that I believe were intended to curb class actions and to focus them into the federal courts. But interestingly, it has also simply, again, created litigation over the pleading rules, over what is or is not class certifiable, what is or is not appealable. I am now the special master class action antitrust case in the Northern District. The case is over 2 years old, and there are still not any operative pleadings. And basically, it's because of the constant litigation over whether or not the new pleading rules have been met. In 2000, we had nationwide mandatory fact disclosure, which increases the discovery burden on defendants. And I would suggest that those alone, when coupled with the 2000 discovery rules on electronic discovery, have taken discovery in the federal courts from the ridiculous to the obscene. The amount of money that is being spent by both sides is really incomprehensible, I think, to those of us who started practicing or more ago. Even without empirical evidence, I don't think there's much doubt that the rules change, decisions, and the legislation over the past few decades federal civil litigation more complex, unpredictable, and costly. And because many state courts follow what the federal courts do in making and in their rulemaking, I suspect that some of the same effect is being seen in the state courts as well. Now, what do we do about it? Well, one way that has come up and that is being taken advantage of is for parties to choose ADR over traditional court litigation, whether that's mediation or binding arbitration or some type of neutral evaluation. The cost-benefit analysis for corporations in particular is much easier to predict, and the promise of finality is a goal worth pursuing. Does that mean everybody should leave the federal courts? Of course not. We do have the best judicial system in the world, and we want it to remain strong. But the courts themselves, I believe, are assisted by having these alternatives available, and I think giving the parties choices in how, when, and where they solve disputes is to the best of all of our interests. Thank you.
Fern, thank you. I'd like to bring in our third panelist, Ken Feinberg.
Thank you very much. I share everybody's view. I'm grateful for the invitation to be here. I'm not sure what the title of this panel really means. Can corporations be brought back? Did they ever leave? Have they left in a greater rate than they used to leave for the last 200 years? I don't know the answer to that question. Tommy Sussman, who heads up the ABA legislative office, here in Washington, he may have some thoughts as to what empirically we know about corporate businesses leaving the judicial system. But it's all relative, I guess. And in the next 6 minutes, I want to just make 4 basic points that I guess we can come back to. First is to the extent that they're leaving for the obvious reasons: expense, inefficiency, uncertainty. We don't trust juries. It takes too long. It costs too much. We don't have the resources. But don't forget that there are arguably doctrinal reasons that that businesses leave the courts. Just look at the law of aggregation in products cases and the attempt to certify classes, or MDL, multi-district panel, thousands of cases. Ken Frazier says, the system works. We had 68,000 cases and we tried 17. So if we had better resources, we'd try 35. I mean, what about the other 67,900 some odd cases? There's too many cases in a lot of areas, brought about, I suggest, for right or for wrong, doctrinal change in the law, which has tremendous implications for American business. Read Justice Breyer's dissent in Amchem and Ortiz, a very practical solution to the asbestos problem. But he couldn't, I don't know legally whether or not, he obviously couldn't get away with it legally. practically the problem would have been over with asbestos. So point number one is, do not ignore, to the extent that there's exits from the judicial system, not only the obvious reasons cited by everybody, but the doctrinal reasons that enter into these decisions. Sheila Birnbaum's here. Ask Sheila sometime to give you her 5, 10, or 20-minute speech on doctrinal changes in the law and how that has influenced corporate decision-making. And Jay Stevens is here. Ask Jay how it works in terms of corporations opting in or out of the system, depending on the law of the state, of the circuit, of the federal district in which they are litigating. So that's point number one. Point number two, to the extent courts are leaving, is the increased sophistication of ADR. It's no longer just arbitration, or as you would say here, arbitration. It's not just arbitration. It's also other creative techniques, not only non-binding mediation, but non-binding mediation with rules and terms and conditions that allows the consumers of the service to frame the process in a way that will serve their interest in getting to a comprehensive resolution. You see more and more of that decision of corporations and small businesses to opt out of a system which is binding and in which they have inefficiencies and concerns, and go into another system where they, at least relatively speaking, control their own destiny. So you see more and more of that as a step designed to give corporations a little bit more control over the ultimate decision that can impact their business. So I think that that is a second reason that you see the growth of alternative dispute resolution. It's consumer friendly. The third reason that you see, I think, in my practice, more and more interest in exiting the courts is globalization, something we heard a little bit about in the first panel. Watch with great interest the effort on the part of the American legal system to transport its system to Europe, particularly England, but also now Europe. And you'll see the growth in England and Europe, not only of doctrinal change, aggregation and class actions, changes in the rule governing attorneys' fees, the willingness of huge investment companies to invest in plaintiff lawsuits in England as a hedge against the loser pay rules. You're seeing more and more this effort on the part of lawyers in the United States to open up offices now in the United Kingdom, in Europe, in an effort to take some of the litigation that grows here in the United States and copycat it and bring it abroad and get a receptive audience. So I think the third reason companies may shy away from the legal system in the United States is you are providing a blueprint for the globalization of the American legal system with all its pluses and minuses. And then there's the fourth very provocative reason that there is a trend, I think, towards ADR, and that is the inherent tension between the judiciary and ADR. When I went years ago, when I was practicing law, the judges that everybody looked to were the scholars. I remember in law school, and I never knew these judges very well, but Judge Janeau of Maine, and Judge Weinfeld in the Southern District of New York, and Judge Weinstein in the Eastern District, and appellate judges, Judge Friendly and other judges, scholars. Today, I watch with great interest the prioritization placed on case management. The MDL loves to send cases to Judge Weinstein in Brooklyn, or Judge Chuck Breyer in San Francisco, or former Judge Milton Pollock, the late Judge Pollock in New York City, or Judge Louis Bechtel when he was serving in Philadelphia. Why? We'll get creative in finding ways to clear this docket. Now, for good or for ill, I don't want to take a position on the merit of any individual dispute, but I want everybody to understand that today, the judiciary itself has a small cadre of judges in New Orleans, judge in Minnesota, that they look to try and deal with this burgeoning docket. When I speak with federal judges around the country, I'm still a little bit surprised at how reluctant they are to embrace any formalized ADR. Appoint a special master? That's not my role. Judge Breyer may do it, or Judge Weinstein may do it, or Milton Pollock didn't do it, he just did it himself. But the idea of the philosophic aversion to a trial judge in the federal or state system having much institutional role in encouraging the appointment of special masters, settlement mediators, distribution agents. It is a very small minority of judges that are willing to embrace ADR as an integrated part of their role. And I think one reason that corporations may very well exit the system is because they're not getting much creativity among the very judiciary that would be well advised, I suspect, to be more creative and flexible in recognizing as part of their own portfolio the opportunity to sort of use ADR under the judicial umbrella rather than say, well, if you want to go use Ken Feinberg, you go ahead, but that's entirely up to you. I'm the umpire. I'll be ready to try the case. And therefore, that's not my job. I suspect that in the year 2008, it is your job. And some judges see it, but most don't. So there are a few points within the 6 to 8 minutes.
And thank you. And our last panelist, Judge Holland.
Thank you. I'd like to join everyone in thanking Justice O'Connor for her leadership and Justice Breyer and Justice Souter for their support. I'm also honored to participate. As you can see, I'm the only court person on the panel, and the questions that we've been asked to address are whether corporations and businesses can come back, should they come back. The third question that I'm going to address, because I answer both questions yes, is how can we get them back? And I think the answer to that is by the establishment of commercial courts or business courts. These questions are really concerned with state courts, not federal courts. We know the strengths of the federal court, but the concerns about leaving courts has primarily been leaving state courts. Many people have heard about the Delaware Court of Chancery. It's 200 years old, and until about 15 years ago, if you asked someone about a business court, they would probably identify the Court of Chancery. But over the last 15 years, that's changed in the state court system. And since 1993, we've had business-type courts established in Chicago and New York. We now have business courts from Maine to Florida, a very successful business court in North Carolina. I was talking to Chief Justice Moyer of Ohio, Chief Justice Ron George of California. They're working with business courts in those states now. And they're working very well. The reason people are going away from courts is because they're looking for economy and efficiency that's not there. They're looking for an impartial decision maker that they don't find, or they're looking for expertise in business or corporate law that they don't necessarily get by random assignment. And in the state system, the real problem has been putting business matters into the general system. And I'm not suggesting that business matters should get special treatment, but they should get fair and prompt treatment. And you can really accomplish that if you establish a business court. Now, I've been asked to speak because for the last 7 years, the United States Department of Commerce Institute on Legal Reform has recognized the Delaware judicial system as the #1 judicial system in the country for fairness and impartiality in litigating business disputes. As you know, 60% of the Fortune 500 companies are in Delaware. More than half of the companies on the New York Stock Exchange are incorporated in Delaware. So that gives Delaware a special interest in this subject area, and it also gives it an opportunity to think about it on an ongoing basis. And I think Delaware's success is attributable to a lot of things. And I know that they can't be replicated in every state, but I wanted to tell you about the Delaware system and why it seems to be working well in Delaware, and to the extent what we're doing appeals to you, it might be something that you would think about in your own state. First, we have a structure of courts that is conducive to doing things in an efficient and economical manner. The 3 business courts in Delaware are the Court of Chancery, the Superior Court, and then those appeals go to the Supreme Court. We don't have an intermediate court of appeals, so that eliminates part of the delay. We have a distinct separation of law and equity in Delaware that we've had since 1792. In business courts in other states, like the federal courts, they combine law and equity, but we really have this sharp distinction. And that's worked well in the Court of Chancery because they've been able to bring equitable principles to bear to business disputes. The other virtue of equity in the Court of Chancery is there are no jury trials, and consequently you have a decision made by one of the 5 members of our Court of Chancery, and that's very important. You have 5 people. When you're talking about stability and predictability, we have 5 decision makers. And over the last century, the law in this area has become pretty well established. When Chief Justice Rehnquist was in Delaware for the 200th celebration of the Court of Chancery, he pointed out that the law has become so well established that it benefits business by telling you how not to go to court, because you can order your affairs in a way to avoid going to court. Now, I mentioned that the Court of Chancery is 200 years old, but it hasn't really been a stagnant court. Although there's this dichotomy between law and equity, we see in the Court of Chancery recent years extending their jurisdiction to complex technology disputes. Again, you go to the same 5 people on the Court of Chancery. And Delaware is one of the courts that embraces mediation and arbitration. And in fact, we have mediation now available by statute with one of the judicial officers of the Court of Chancery if you're incorporated in Delaware. So it's another track you can elect to take. Our Superior Court is the general jurisdiction court, and that's where we have the complex commercial litigation type matters. And we see that court doing a lot of things with electronics, and we also see an effort towards specialization. And that is something I think that could be considered in other states, because our general jurisdiction court also has death penalty cases and other matters, but by moving the commercial matters into a separate docket apart from criminal cases, they're able to move along much more efficiently and expeditiously. And as Ramona was saying, DuPont, for example, has had a good experience in Delaware with asbestos cases because they were assigned to an individual judge. The judge stayed on top of the case, dealt with case dispositive motions, and kept things moving along. So you didn't necessarily have a jury trial if there were either summary judgments, motion to dismiss, or Daubert motions that were decided in favor of the corporation. That doesn't mean the corporations are going to win. It simply means, as the Chamber of Commerce has observed, they're going to be treated fairly and impartially. Now, both of those courts take appeals to the Delaware Supreme Court, and our jurisdiction is mandatory. We have no discretion. We have to take the cases. But one of the things that's commented on frequently about the Delaware Supreme Court is what's known as its unanimity norm. In the last 50 years, less than 1% of our entire docket has involved divided decisions. Now, that doesn't mean that we agree for the sake of agreeing. Everybody has written separately. I look at all of my dissents as failures of my powers of persuasion. But we do write separately. But the advantage of trying to narrow our holding, decide the specific case, is that we provide stability, certainty, and predictability for the law because you're not trying to figure out where it's going to go based on a unanimous decision. Now, the other component that helps with Delaware's impartiality is our selection system. Delaware is one of about 10 states that still appoint judges. We appoint the judges based on merit selection. You're appointed confirmed by the Senate for a 12-year term, and you know the court that you're going to go to. So consequently, when you're talking about commercial courts or business courts and people with expertise, the people that are appointed to the Superior Court, the Court of Chancery, and the Supreme Court are all selected and appointed with an idea of the judicial function they're going to discharge. Now, another thing that's unique to the Delaware Constitution is a requirement of political balance. Our Constitution has a provision that says there has to be balance in every court and all of the courts between the two major political parties. And that came about in the Constitution of 1897 with the idea to keep the courts impartial and non-political. The debates themselves said, we don't want to elect judges because, you have to pardon me, they quoted, they elect judges in Pennsylvania and that doesn't work very well. And then they also said, to the extent we don't want to elect judges, we also think if everybody gets a turn and we require political balance, everyone will just focus on selecting the best person. And that has worked fairly well. The last point I'd make about the Delaware system also relates to efficiency and economy. We have a rule in all courts and in the Delaware Supreme Court that matters have to be decided within 90 days of submission. So when you come to court in a business matter, you have a pretty good idea of when your case will be resolved. And that's all cases, not just criminal cases. And we do that, and we can expedite cases. To give you an example of the Court of Chancery's ability to expedite cases, earlier in September, just 2 weeks ago, there was a 6-day trial involving a multi-billion-dollar merger. The trial ended on September the 19th. On September 29th, 10 days after the trial, the Court of Chancery issued a 91-page opinion dealing with that multi-billion-dollar merger. Now, it's possible that case is on its way to the Delaware Supreme Court, and it's likely that it will be expedited in the Delaware Supreme Court. But this is the routine way the court conducts itself. In fact, last year, the average time of disposition in the Delaware Supreme Court from submission to decision for all cases was 37 days. So after the oral argument, you'd have a written opinion in 37 days. Now, this is a function of the way courts are set up in Delaware, the way the judges are selected. And my final point is the significance of individual case assignment. The American College of Trial Lawyers just issued a report 2 weeks ago on its assessment of the civil litigation system, and they talked about the fact there's a need for judicial involvement. Individual involvement, case scheduling orders, pretrial stipulations, as I mentioned, case dispositive motions. So I really think if people are going to come back to the court system, it is only going to be if the courts can produce the results that you would get through the alternative with arbitration or mediation. So in conclusion, I would simply invite you all to come to Delaware.
Thank you very much. Time is short, but I'd very much like to open it up to questions from the audience. Don't be shy. If you're too shy, I'll have to ask one of my own questions, which I have ready. I'll begin then with one of my own questions. One of the things, or one of the headlines I've heard here is that we don't want ADR to supplant the courts. Is there a way to develop a better partnership between the two, a partnership that would allow some of the steam out of the system? Maybe you'd like to begin.
Well, I think, at least in my court, which it'll always be my court, even though I'm retired from it now, I think there is a partnership. And First of all, ADR has been used in the California courts for a long time, and I know the rest of the country thinks we're all crazy in California, but the truth is that eventually whatever we do tends to wend its way eastward. So we started ADR early, and right now I would disagree somewhat with what Ken said about the tension, because I don't find it in our courts. I find the judges are very anxious to utilize ADR when they believe it's appropriate, when they think it will be well received, and when they believe all sides are able to afford it. And that has to be a huge factor. But I think in the sophisticated jurisdictions, and certainly we're not the only ones, there is an acknowledgement today that the courts are overburdened, they are under-resourced, and that ADR can provide a very good adjunct to what the courts are doing. I don't think ADR ever expects, wants, or should supplant the courts, but they can certainly assist the courts, and they can help. The pipeline right now is full. It's not that there are necessarily more cases in the courts. There are more big cases in the courts, more complicated cases, more expensive cases. And those cases take more than their fair share of what the judicial resources are. And so this is a way to provide those parties who have the resources, who have the interest, who have the sophistication to use ADR. It provides the judges with a way to help give more time to those other cases, and everybody profits. I don't think it's a competition. It shouldn't be a competition. When I first took the bench in 1988, there was a division in our court about case management. The old-timers said, I've been doing it this way for 30 years, and I'm going to keep doing it. You set a trial date, you send them away, you don't see them again. And that's the way they wanted it. Now, we wouldn't think of not having case management. And I would hope that with a little more time, a little more comfort level, that ADR will take the same kind of place. It will be seen as an asset and as an assistance rather than a competitor.
And do you see it that way?
No, wonderful. Great.
Now tell me why
I've never met a judge who didn't say, oh, but we're on the good side with ADR. Judge George last night, Ron George, and Judge Holland, and now Fern Smith, everybody, well, we understand that philosophic aversion to ADR, but not us. Fine. I just don't see it as very pervasive around the country. But I haven't mediated in Delaware lately. So.
Yeah, sure, please. Please come on down to the microphone, if you don't mind, so we can all hear you. And just please identify yourself and your affiliation. And,
this is what you call getting yourself in real trouble.
Ken just did. I am Ron George, the Chief Justice of California. I just have a question, maybe for Judge Smith, maybe for someone else. Is there any concern that by resort to ADR on some of these very complex cases, some of the most important issues will be resolved without any precedent being established, and that even aside from other parties in the future, the very same parties may have a similar dispute in the future and have it resolved quite differently without reference to the earlier case because there is no precedential value? That's my question.
Maybe Justice Holland, you'd like to begin?
Well, I think that has to be the biggest concern. When we talk about mediation, arbitration, any type of alternative dispute resolution, everything is predicated on what a court would do if you went to court. So if we don't take these cutting-edge issues to court and establish the precedents early, there's not going to be a benchmark for doing the alternative dispute resolution. And so I think that's an ongoing concern. And if you go back to Merck's example, I think that's what they were doing in a different way. They tried 17 cases that, provided the basis for settling thousands of cases. But I think in the absence of clear judicial precedents, alternative dispute resolution and ADR isn't going to work.
And I think that companies are cognizant of that issue. I mean, I think that it plays both ways, obviously. Sometimes you want to stay out of court in order not to make precedent, but there are some issues on which you really have to stand up and be counted.
Do you agree with that, Ken?
I do. It's a big problem. In the 9/11 fund, we settled 5,300 cases. 94 people went to court instead before Judge Hellerstein in the Southern District. Exactly your point was raised. There's a limited amount of money available for the settlement of the 94 cases. How do those 94 settlements compare to the money being offered in the 9/11 fund, and how do we make sure that there's some integration of value when both settlements are confidential? The 9/11 fund, we were strict about not letting anybody know what the values of those cases were, and Judge Hellerstein was scrupulous in trying to keep that sealed. And yet at the same time, I'm being asked by Judge Hellerstein, and I'm asking Judge Hellerstein, can we somehow make sure that the system isn't skewed one way or another, which will lead people to leave one and come to the other? And we managed to do that, but it was very, very difficult because of the absence of transparency in those privately negotiated settlements. It was a big problem. Fortunately, a federal judge who was very tuned in to making sure that the systems dovetailed, or it would have been a real problem.
But could I just add maybe a slight contrary note? Because what you've expressed, Justice George, is a very, very real concern, and I'm aware of that, and I don't downplay it at all. This is an incredibly litigious country we live in. There is more than enough precedent to go around. Certainly in our state, as you well know, above and beyond everybody, ADR is never going to take the majority of the cases or even a significant portion of the cases. And so I think there's a difference, again, between supplanting the courts and simply providing a little assistance to them. And I would hope that that balance would be maintained.
Well, thank you very much for the question. Thank you. And that wraps up this panel. It's been an excellent and rigorous discussion. Hopefully we can continue into our lunch break. I'd like to hand it over, though, first to Meryl Chertoff.
Thank you very much. Thank you very much.
Thank you. I enjoyed it too.